Right, so I'm going to take the next video, which is video 3 in our series of Unit 2 exam prep. And I'm going to do it out of context slightly. And I'm going to introduce to you the level of harm chart. And the reason that I'm going to do that is that I think it's the biggest sticking point for students being successful in this exam is the confidence that they have and their ability to identify clearly the right offence to talk about. So what I've done is I've created the level of harm chart. Now, of course, you won't be able to take this into an exam, but what it should do is, if you learn it, give you the confidence to be able to look at questions and clearly identify the offence that has been committed. So without further ado, let's take a look at the chart. And the level of harm chart can be downloaded free from www.thelawbank.co.uk. If you just go to free resources, it's one of the 3 documents that is contained at the bottom. And what I have done here is I've clearly set out the 5 non-fatal offences that we cover in AQA, and incidentally they're the same offences that will be covered in all of the other examination boards, and I will deal with examination questions for the other boards in due course. As I say to my students all of the time, when looking at an exam question, the very first thing that you need to do in terms of what offence it is to look at the level of harm. And the reason for that is it is the level of harm that distinguishes which of the offences apply. How much harm has the defendant caused to the victim? And the way that we find that out is by applying the case law definitions of those levels of harm. I'll explain what I mean. I've divided assault, battery, ABH, GBH section 20 and GBH with intent section 18 into the 5 parts of the chart. What I've then done underneath is to contain or to place the level of harm that applies to each of those offences. So for assault, the level of harm is an apprehension of unlawful personal violence. Now, this is a definition, of course, comes from Ireland and Burstow. And I'm just going to talk about the statutory provision around assault and battery in a moment. But essentially, assault is about apprehension or expectation. So this means no touching. It's about what somebody apprehends or expects. For battery, the level of harm is the merest touch, and that definition is contained within Thomas. For ABH, our level of harm is any hurt or injury calculated to interfere with the health and comfort of the victim, providing it is more than merely transient and trifling, and not wholly insignificant. And that definition comes from a series of cases, but predominantly Miller and Chan Fook. GBH is defined as really serious harm, which is Smith, of course. Or when we're talking about a wound, we can also talk about a break in the continuity of all layers of the skin, and that's JCC versus Eisenhower. Now, the difficulty that you have with GBH section 20 and GBH with intent section 18 is that the level of harm is the same. So these 2 offences are slightly different in that they are distinguished by their mens rea element. So, and of course, without teaching you to suck eggs, the mens rea element for GBH section 20 is a foresight of some harm, whereas the GBH with intent section 18 is the intention to do grievous bodily harm. So a specific intent to do grievous bodily harm or a foresight of some harm. But the level of harm is the same. Now, what I've got up here very, very clearly is the fact that assault and battery are common law offences, although their provision is now made statutory in section 39 of the CGA 1988. And that just pretty much says that they are stand-alone offences, although together combined they underpin the definition of common assault. Whereas section 47, section 20 and section 18 are statutory offences and are contained in the Offences Against the Person Act. So all in all, that's a sort of basic idiot's guide, if you like, to what offence has been committed. So let's have a look at what that means in practice. I've taken a very short scenario from the January '07 paper. I'm not going to insult your intelligence. You can read it for yourself when you see it. So either download the January '07 paper from the website, or you can see it there in its full glory. But the scenario takes us through very clearly the process of, or the sequence of events. And then when we look for the level of harm, because the question asks us, ignoring the driving offences, what is the criminal liability of Alan for the injuries caused to Dennis? So the injuries caused to Dennis, if we read through the scenario, are here. Fractured spine and permanent paralysis. So the way to decide what this is by going back to our chart. Now Dennis suffers a physical injury, so it has to be more than assault, which is just an apprehension. So then it's just simply a process of working through which of the others best fits the bill. And quite frankly, a great deal of this is common sense. So the questions that you need to ask yourself is a fractured spine and permanent paralysis equivalent to the merest touch? Well, quite obviously it's not. So therefore that rules out battery. Is it a hurt or injury calculated to interfere, and that's the key word here, interfere with the health and comfort of the victim? Well, quite obviously, it's more than just interference. Dennis has a fractured spine and permanent paralysis. So that can only be really serious. So we immediately know, applying this structured approach, that the offences that we are looking at in terms of criminal liability for Alan have to be either Section 20 or Section 18, because the injuries fit with really serious harm. Now, in order to distinguish between the two, what we will have to do in our answer is we would have to look at whether or not Alan had a foresight of some harm, or whether or not he actually intended to do grievous bodily harm. And that's the point of this video, is not to discuss that and not to answer this question. It is to identify the offence that we are looking at. And here it is either Section 20 or Section 18. Now, here's one clear thing that you need to be able to do, and it's the last point that I'm going to make on this video. With the exception of assault, so forget assault, when you are discussing which offence is applicable, you are always going to have to discuss two and to discount one. So you are going to have to say, is this a battery or is it ABH? And you'll do that by saying, does this fit the merest touch, or does it interfere with the health and comfort of the victim? And you will write one off by saying the injuries to X are more than the merest touch, and therefore they need to they interfere with the health and comfort, which means that they are going to be Section 47. Similarly, so if it's slightly more serious, you will make a comparison between, is this really serious harm, or is it a hurt or injury calculated to interfere with the health and comfort? In this instance, I think X is liable for, because the level of harm is whichever. And what that will do is that will demonstrate to the examiner that you've considered the two possibilities, you've thought about the level of harm, and then you've made a very clear decision as to which of the offences it is. That comparative discussion for Section 20 and Section 18 takes place involving mens rea. So for battery and ABH in Section 20, the discussion about which one it is going to end up talking about the level of harm. The comparison as to whether or not it's a Section 20 or a Section 18 is going to involve the discussion of intention and mens rea. As we work through the January 2011 paper, we'll demonstrate the use of this principle further.